Did the High Court case against Tommy Robinson prove beyond any reasonable doubt the definitive truth about what happened at that school? The answer is no, for two reasons. There's a simple reason and a much longer reason, which I would encourage you to stay for the rest of the video for. And I must also say that whilst I'm talking about this judgment and various bits of it in this video, you must rely on the full judgment, which I will link below as the definitive word of everything said in this case, and any errors on my part will be cleared up by that contained within the judgment. The simple reason is that that is not the standard of proof upon which the High Court decided this case, because beyond a reasonable doubt, so that you are sure that this is what happened, would be the criminal standard of proof. This was in the High Court, which was on the civil standard, which is more likely than not that this is what the court found. And even that is particularly nuanced in the way that the court decides it, which brings us into the second reason. Now, the second reason is a lot more difficult to explain, but hopefully you'll stick around for it. The way that the court decides what happened when a case comes to court is on evidence. The court can only decide a case on evidence. If there is no evidence of a claim, the claim will fail. If there is no evidence of the defense that is proposed, the defense will fail. So very often, if you have a defendant coming forward to say what they say happened, but they provide no evidence of that, and there is absolutely no evidence upon which the court can decide that that is the real defense of what happened, that defense is likely to fail. Now, at this point, I'd like to thank everybody that subscribed just recently, because that has brought the not subscribed viewership number down to just under 54% from about 70% originally. So thank you for that. But it's still over half of you that watch that don't subscribe to my channel. I'd be really grateful if you did. That will really help me to reach a wider audience. So now allow me to explain in a little bit more detail how the court decides these cases. So there's a statement of case by the claimant. This is what they say happened. Now, in this case against Tommy Robinson, it was one of defamation. So the claimant argued that his statements were defamatory and that they caused or were likely to cause serious harm to the reputation of this claimant. And Tommy Robinson argued that what he said was essentially substantially true. Now, for the claimant, it went to court and the court decided the ordinary meaning of the words and that they were defamatory. And Tommy Robinson brought evidence to court to try to prove that what he was saying was true. Now, in order to assess this case, the court had to look at all of the evidence. Now, the evidence can come from witnesses. Now, there's an important distinction as to whether someone actually turns up to court or makes a statement but doesn't come to court. That's called hearsay. Hearsay isn't just someone told someone and then you put that in as your own evidence. That's not necessarily how it works. Hearsay can be a written statement by somebody that is not willing to come to court or is not summoned to come to court. And so when you serve your witness statements of those that will come to court, you can also serve, and it should be served at the same time, a notice that you intend to rely on the hearsay statement of a party who is not coming to court. And that happened in this case. And there are some special rules about hearsay, which I'll come back to in a moment. Now, these witnesses, when they come to court, obviously their account will be tested under cross-examination. So in a civil case, as a standard, their written evidence will form their primary evidence. We call that evidence in chief. And then they will be cross-examined. In other words, the opposing barrister will test their evidence. They'll put inconsistencies. They will put challenges to their credibility. And they will essentially challenge them on bits of their evidence as to why they say they either might be mistaken or misunderstood or flat out lying, perhaps. Although it's rare to suggest that they are lying unless there's definitive proof. It's more likely that they are inconsistent, misunderstood, and so on. Secondly, the court will look at documentary evidence. So that can be contemporaneous records, that can include CCTV or written documents and things like this. So the court will look at documents as well. They are very often seen as reliable by the court, not definitively so, but they are very often seen as reliable by the court. But not just what they do say, but what they don't say can also be interesting. So for example, if somebody traveled to another country, we've had this in a real case, somebody said that they were in another country at the time, but had no documentary evidence of it whatsoever. And so the argument clearly was, well, if you did go to that country and you were in that country at the relevant and material time, you would have most probably a travel document between your house and the airport if you took a taxi, or if you took your car somewhere that you parked your car, or if you took a bus, and so on and so on. But moreover, you would have had a flight ticket, documentary evidence that you flew from one country to the other, hotels in the other country, bills of all sorts of other stuff in the other country. It was quite a ridiculous suggestion to say that they were in another country when they had no documentary evidence of it whatsoever. So a lack of documentary evidence can be evidence in itself. Now, on another note, just for a moment, a few people have asked in the comment section about how to stay safe online when using social media and making comments freely, and how to avoid being tracked and traced if that's something that you're worried about. One of the best ways of doing this is by using a virtual private network. As you know, I am supported on this channel by NordVPN, which is one of the fastest VPN services. They are in 111 countries, and they have a zero logs policy, meaning they don't keep any tracks and traces and logs of anything that you do online, which ordinarily will be scooped up by your internet service provider, which includes the incoming and outgoing IP addresses, websites you visited, the connection, duration, what data's been transferred, websites you visited, files you've downloaded, any software that you've used, and all of these kind of things, which if you want to avoid being tracked and traced and have your every move monitored by your internet service provider and anybody else that has a legitimate claim to see that information, you can use NordVPN as your virtual private network to shield your internet traffic from your internet service provider. That means they can no longer see any of this information online. NordVPN has been audited a number of times by large independent companies that backed up their assurance that they have an absolute zero log policy. Of course, as a partner to my channel, I can offer you a fantastic discount to the service, which on this Black Friday exclusive is a significant discount plus 4 extra months free if you use my code, which is BBB, which is the nickname you gave me. So if you hop over to nordvpn.com/BBB, the link is on screen and in the description below, you can avail yourself of this huge discount and a 30-day money-back guarantee if you change your mind. But with the peace of mind knowing that your internet activity is shielded on all of your devices, this is very much worth it. In addition, it also comes with anti-malware protection, advanced browsing protection, so it stops you from visiting dodgy websites and downloading dodgy files. There's even a data breach scanner and encrypted cloud storage you can take advantage of. So check out nordvpn.com/BBB on the screen and in the description below and get this fantastic discount for that peace of mind knowing that you can browse securely and privately. And as I said, hearsay evidence, there are specific rules about hearsay and the weight that a court will attach to hearsay evidence. And this comes from Section 4 of the Civil Evidence Act 1995, which says, in estimating the weight, if any, to be given to hearsay evidence in civil proceedings, the court shall, means it's got no choice, it shall have regard to any circumstances from which any inference can reasonably be drawn as to the reliability or otherwise of evidence. So, for example, if you had a written documentary transcript of what somebody said in a covert recording, which is relevant to this case here, if there was a transcript of what somebody said in a covert recording that was unchallenged, asked by leading questions, you would agree with this, wouldn't you? And they said, perhaps, yes, I would agree with that. That's obviously a leading question, and if it was a covert recording and they were prompted by somebody or pressured by somebody and things like that, not to say that's exactly what happened here, but generally speaking, then a written transcript of that hearsay evidence may be much less reliable because those are the circumstances in which this evidence was obtained, and therefore the court will decide what weight, if any, and credibility to be given to this hearsay evidence based on any circumstances and the inference that can reasonably be drawn from those circumstances as to the reliability or otherwise of that evidence. Regard may be had in particular to the following: whether it would be reasonable and practicable for the party by whom the evidence was adduced to have produced the maker of the original statement as a witness. In other words, if somebody has been recorded saying something and that evidence is brought to court, the court can say, well, would it not be reasonable for that person to come to court to give that evidence themselves on oath and be cross-examined and challenged on that evidence? And if that's reasonable and practicable, then surely they should have done that. And if not, then again, it's something that the court can consider. One of the reasons they may not is if they're not in the country, or in some situations, they might be dead, for example. So obviously they can't then come to court to give evidence, and it might then be hearsay evidence. But then we have other rules, such as res geste rules and things like that. More about that in another video, perhaps. Also, whether the original statement was made contemporaneously with the occurrence or the existence of the matters stated. So, in other words, if they had a covert recording or they even made a written statement some 2-3 years after an event, their memory and recall may not be as good as it should have been, as though it was done the day after. So the police, for example, like to interview you as soon as possible after an incident so that you have a contemporaneous record of what was said and what happened, as close as possible, as contemporaneous as possible to what happened in respect of the matter stated. Now, I will relate all of this to this case in just a moment and explain how the court addressed all of this and what the court said about the truth about what really happened in this case. Whether the evidence involves multiple hearsay. So first level hearsay would be one person's written document or record of a conversation coming into court when the person doesn't come to court. That's hearsay level 1. If they say that they heard somebody else say something, so they are recounting the words of a second person, that is then multiple hearsay, because not only is that person not coming to court themselves to give evidence, but they are recounting the words of somebody else who is also not coming to court, so that is multiple hearsay. And worse still, if they say, well, my friend told me that his cousin saw this guy doing something, then obviously that's so many levels of hearsay, it is just impossible to rely on it. Furthermore, whether any person involved had any motive to conceal or misrepresent matters. So if they were close to an incident and it would affect them, the outcome of what they are saying, and they are saying one thing to try and make it believable and credible, but they don't want to come to court, then there's obviously a conflict there. On the one hand, they're not coming to court to give evidence in person, but they would like their account to be believed because perhaps they are close to a subject matter or it does directly affect them. So if you think, again, in the abstract, if you think of a case where somebody saying something would benefit them financially, they obviously have a good reason to say it. But if they're not coming to court, perhaps because they don't want to be caught out in a lie, perhaps that might be a good reason for them not to come to court, but they do want to make the statement. And so all of that taken together, the court can place no weight, if it so chooses, on that hearsay statement. Furthermore, whether the original statement was an edited account or in collaboration with another for a particular purpose. So if somebody is solely gathering information for a particular purpose to prove a particular thing, that can be important. Also, if it is edited, for example, they talk for 15 minutes and the one sentence in the middle is taken and perhaps taken out of context, but relied upon by itself and absent anything else that was said in context that might change things. For example, if the only statement that you heard was, yes, I saw him beat this guy up, if that was by itself, that might sound damning. But if the surrounding material said that that person was under attack by a mob of other people, and the net result is, so yes, I saw that guy beat this guy up as the net result, then obviously that gives it a different context. And so any editing can affect the weight that the court places on this evidence. And finally, whether the circumstances in which the evidence is adduced as hearsay are such as to suggest an attempt to prevent proper evaluation of its weight. Similar thing, really. So if evidence is gathered in a way so that it is just to persuade you by gathering that hearsay evidence, and there's no real attempt to show the truth, not saying that's what happened here, but if there was no real attempt to discover the full truth or bring them to court to provide the full truth, and that there's potential reason to obtain it by hearsay and not bring them to court, again, that could be relevant. So now coming back to what this case said about, quote unquote, the truth of what happened at this school. And I'll mention first of all the documentary evidence that the court relied on in this case, and then I will look at some of the conclusions to show you how, when looking at the evidence and considering the evidence, i.e. witness evidence, hearsay evidence, and documentary evidence against the claims made, and the claims including the claim of what the truth was, to defend this claim, you might then see how this evidence fits into place and how the court assessed the evidence and how the court drew its conclusions in this case, and that it's not necessarily to say that this is absolutely definitively the truth, just that on the balance of probabilities, this is what happened. And that is the civil test upon which the court decides these cases. So first of all, looking at the documentary evidence here. Now, the court at paragraph 42 here set out that the other main source of evidence are the substantial school records that have been obtained in relation to several pupils at the school, including in particular the claimant, Bailey, Charlie, OTP. Both parties, that being the claimant and the defendant, have obtained these records, usually following subject access requests made by or on behalf of the relevant pupil. Understandably, before being provided in response to the relevant subject access request, and although there were some redactions and more than one copy of documents provided in response to different requests, etc., the judge said, "I'm satisfied this variance is not because of anything sinister or untoward. It's likely to reflect the idiosyncrasies in the approach to redaction of the records carried out, probably by different people on separate occasions, and there's been no challenge to the authenticity or admissibility of the documents." So these documents, as they were from the school, were authentic and proper documents that the court could rely on in accordance with the rules. Now, the important bit is here, that the bit that I've highlighted. The court said here, because I've had one or two emails about this, sort of complaining that I've taken everything the court said and everything that the record said as the absolute truth of what happened. Now, I'm not addressing any one particular email specifically, but I thought this would feature in this video because it's important for those people that do want to hear it, that the judge did indicate here and specify that this is not necessarily the absolute truth of what happened. It's not to say that it's false either, because for reasons I've explained, you do need to look at the full judgment to draw your own views on it, and the court's ruling is the court's ruling. The judge said, in this case, the school records are, in my judgment, important for two main reasons. First, they are contemporaneous records of events at the school. So there were documentary evidence of what happened made at or around the time of those events at the school. So either what was documented or what was not documented, they were done at and around the time, so they are much more likely to be reliable. That is not to say, the judge said, that is not to say that they can be relied upon necessarily as demonstrating the truth of what happened in various incidents. Many of the documents simply record what was said by those who claim to have witnessed or been involved in the events. In places, those accounts conflict. Nevertheless, they are valuable as contemporaneous records of the various accounts. Second, they are important in the assessment of the credibility of some of the witnesses, and there's various case law to support that contention. And so, using that argument that these documents were contemporaneous records, they were valuable documents to try to unpick what happened on the balance of probabilities, but not beyond a reasonable doubt, just on the balance of probabilities, just whether the judge accepted that these claims made were true to support the defense that this was substantially true. Obviously, the judge ultimately concluded that it was not substantially true, and the judge rejected that defense. But now let's move to one or two of the conclusions of each of the incidents that was set out in this case by Tommy Robinson and or his legal team to support this defense of the truth. First of all, for this incident one here, the judge said, "I can state my conclusions on this incident shortly. The defendant contends that this incident shows that the claimant has a propensity to use violence and is a bully. In my judgment, it doesn't establish either. BWI did not claim in his evidence that he was bullied by the claimant. So the one person who was at the heart of this did not claim in his evidence that he was bullied by the claimant. That was just in respect of a specific incident." The judge said at the end here, the bits in blue, "I cannot accept his evidence as truthful. He appeared to me to tailor his evidence in a way that he thought supported the accounts that he'd heard by BWI in his evidence. His evidence about the incident was unconvincing, embellished in the witness box, and I cannot accept it as reliable or credible." So again, taking the claim that's brought into court, the judge will look at the witness evidence, any hearsay evidence, any documentary evidence, which bits are credible, do they support the claim that is made, yes or no? That's not necessarily to say it's the absolute definitive truth, it's just, does the evidence support the claim that's being made? And in this case, the judge said here that the evidence from the witness was unconvincing. It was embellished, so adding extra detail in the witness box to try to convince you of something. So if someone is trying to convince you that something happened, they might add extra details in there to really try and convince you that this really happened. And when challenged on it, a lot of those bits then fall away because they didn't really happen, or it wasn't really like that. And so therefore, they've tried to convince you that it was true, which they probably wouldn't do had it really been true. Next, I'm just going straight to the summaries here, the bit in blue. In summary, the defendants failed to demonstrate that the claimant had any propensity to behave in an aggressive or abusive manner towards girls and women. Again, that is not, as the court said earlier in the judgment, it's not necessarily the definitive truth, but the defendant has failed to demonstrate that with the evidence that this was the case. For reasons I've given, I'm unable to accept the evidence of AYQ and BWI, but even if I had, it would not have demonstrated a propensity on the part of the claimant to act in this way. So the evidence that they gave, the judge didn't accept. But even if the judge did accept that evidence, that did not show the propensity to act in that way. The more reliable contemporaneous evidence, the judge said, in the school records provides powerful support for the conclusion that claimant did not behave in the alleged way. That was because the school records did not show the aggressive behaviour and did show that actually was well behaved. And again, I've addressed that further in the other video and in the full judgment, which I will link in the description below for you to go and read. The next conclusion, again, you'll note the wording of how the judge describes this here. The judge will say, on balance, and, I accept this and I reject that, and then come to a conclusion. So again, here, and you can see this bit here, the defendant cross-examined the claimant about the incidents in respect of the first, etc. And in blue here, on balance, I accept the evidence of the claimant in respect of the incidents. Even if MYV's hearsay evidence is admissible, again, remember the arguments about whether evidence is admissible or not, as to which I have real doubts. So the judge is doubting here whether that hearsay evidence is admissible. I can attach no real weight to his untested evidence, particularly in the circumstances in which it was obtained. And again, talking about the way that hearsay evidence is gathered is important, as we set out from the Civil Evidence Act. Again, in blue. But without any idea of when this is alleged to have happened, it's impossible to even begin to investigate it. The defendants failed to prove MYV's allegations. And this was regard to the use of a toothpick in the hand, etc. More importantly, the judge said the evidence of these incidents relied upon by the defendant, even had I accepted MYV's evidence as truthful, is not remotely capable of demonstrating that the claimant had the propensity towards using or making threats of violence towards other peoples. So again, just drawing conclusions based on the evidence that's brought to court. Next, again, talking about likelihoods here. The bit in orange, first of all, there's no reliable evidence to suggest the claimant ever had a knife in his possession at school. This was whether it was a knife or whether it was a screwdriver and so on. The judge said, moreover, the likelihood of the reporting the discovery of the screwdriver to his head of house, if in fact the item was his, is so remote it can be discounted. So the judge is essentially saying, and you may not, you're entitled to disagree with this, but making public statements about it as fact might be another thing, but you're entitled to disagree and challenge it. But the judge is essentially saying that he found this screwdriver in his bag and reported it to head of house. And so it's unlikely that if it was his, that it would do that because it would get him into trouble. I'm adding the last bit myself, but it's a reasonable inference to make. Equally, the judge said reporting the incident to his parents is not a step that the claimant would have taken if the screwdriver was his. Stepping back, the defendant is seeking to demonstrate, as a matter of fact, that the claimant had gone to school equipped with a screwdriver and a knife based solely on the minutes of a meeting. This was the meeting between the school and the parents. I do not know who completed these minutes, when, and based on what records. Against that, I have the sworn evidence of two individuals with direct knowledge of the events, and I accept their evidence. So again, the judge is just saying, well, I've seen the records, I've seen the allegation made, and I've heard direct witness evidence, and I accept that evidence. And therefore, the judge said, for the reasons I've stated, I reject the propensity evidence relied upon by the defendant, by Tommy Robertson. I'll now turn to consider the evidence on the other cases. Furthermore, the judge says the defendants failed to prove the group attack incident. This case depends entirely upon hearsay. There is no direct evidence from EYW herself, even by hearsay. Despite her apparent reluctance to even speak to him, the defendant could have secured the attendance of EYW at trial by the use of a witness summons. Because if you come to court, you can summon somebody to court to give evidence, and that's how that works. The evidence relied upon by the defendant amounts to second-hand hearsay from EYW's mother in respect of allegations that she's publicly disavowed. I cannot attach any weight to this evidence. The hearsay is untested by cross-examination. The recordings of EYW's mother have been edited, so I only have a partial transcript. That's the bit that I was talking about earlier. There are clearly other occasions on which EYW's mother has given details about the allegations about the attack to the defendant, but I do not have a record of what she said. The two recordings were obtained covertly. There is no indication when the alleged assault took place, but the hearsay accounts of it are not contemporaneous. So again, just looking at how it was obtained, when it was obtained, whether it's been edited, whether it's first or second-hand hearsay, and then whether it's reliable and so on. And therefore, the judge said, against that, the claimant has given sworn evidence at the trial and been cross-examined. I have no basis on which to reject that evidence. Indeed, I find the claimant to have been credible and truthful throughout his evidence. As a result of my conclusions in relation to the hockey stick incident, the group attack incident, the defendants failed to prove the substantial truth of imputation 1. Now, again, looking back to the documentary evidence, which somebody did, one or two people emailed in about, the documentary evidence of the school does not necessarily prove the whole truth of exactly what happened. The judge accepted that. But taken with all of the other evidence together, the judge will draw a conclusion based on the evidence. So he's essentially taking here, and again, you're entitled to disagree with it, but the judge is taking direct sworn evidence at trial, which was tested under cross-examination, against evidence that the court just did not place any weight on because it was untested and it was second-hand hearsay and so on. And finally, again, you'll note the wording here. The judge said, on balance, I consider that the claim to have been told that the claimant has threatened to stab him or anyone else was manufactured by Bailey. He first gave this lie in the account that he gave in the incident report as an effort to try to excuse his attack on the claimant, and then went through other reasoning. And then the judge said, for these reasons, the defendants failed to prove the substantial truth of the imputation 2. In consequence, the defendant's truth defense must be rejected, and the judgment on the claim will be granted. And so just summarizing all of that, what the judge has done is gone through each incident that was relied upon to support the defense of the truth. And the judge has said, well, based on the evidence that's come forward, whether it's record evidence, whether it's contemporaneous, whether it's hearsay, second hearsay, whether it's obtained covertly, whether it's edited, whether they've stood by that account and come to court, whether they've been summoned to court, as against direct testimony evidence that has been tested in court, etc., the judge brings all those together and comes to a conclusion. So as I said, as the judge said in the outset, these school records here, the judge said, that is not to say that they can be relied upon necessarily as demonstrating the truth of what happened in the various incidents. Many of the documents simply record what was said by those who claim to have witnessed it or been involved in the events. And in many places, they conflict. Nevertheless, they are valuable. So for those worrying about whether or not those are being relied upon as absolute truth as to what happened, not necessarily. The judge said as much in the judgment. But as I said at the outset, I would encourage you, before drawing any firm conclusions on any of this, the judgment is linked below, and you must take that as the definitive word because it is the full judgment, and my video here is obviously just a summary of what happened. But I hope that was useful because a lot of people have asked further questions about this from my previous video about how the judge weighed up the evidence in this case. So I hope that's been useful. If it has, please do hit the like button, subscribe, hit the notification bell so you'll get notification of new videos. And as always, thank you for watching.